Bonjour à tous. It's my job this morning to talk about oil sands, greenhouse gas emissions. So, on the screen, you see numbers. This is the pretest. Take a look at the numbers. What do they mean? The first two numbers tell you something about oil sands and the significance of oil sands for Canada's oil and gas industry, and indeed, ultimately, for the Canadian economy. 97%. The oil sands constitute 97% of Canada's oil reserves. The third rank refers to global oil reserves. Canada is third. These are 2016 numbers, but little has changed in the last couple of years in this regard. So these are significant oil reserves. Canada is an oil state. If you look at the size and the significance of Canadian oil reserves, of which 97% are in Alberta's oil sands. And if you look at the map, the part shown in red, particularly that part in the eastern side, that's the main oil sands area. The other part toward Peace River in the on the western side of the province, that's essentially heavy oil. But the main oil sands area is enormous. It's roughly comparable to the size of Scotland. Okay, it's a huge area. The bottom two numbers, 71.7 megatons and 10%. These numbers refer to greenhouse gas emissions from the oil sands. So 71.7 megatons is the amount of greenhouse gas emissions from the oil sands as of 2016. And that has increased and little, and may actually have decreased, simply because all of the oil sands projects, the literally hundreds of billions of dollars of new oil sands projects that the industry was rubbing its hands together about, if you go back to 2014, completely fell off the table in 2015, right? When oil prices crashed in 2015, those projects pretty much disappeared. There are two new projects that have appeared just in the last year, one by Teck Resources, which was mentioned yesterday, and there's a Shell project in the wings as well. The Teck project, you think about Teck as a miner, okay, but this is mining as well. The Teck project is in the EIA phase of the approval process. So all of that gives you a little bit of a picture of the size, the global significance, and the significance of greenhouse gas emissions from Alberta's oil sands. And I've alluded to this already. The way to think about the oil sands is there are two parts. One is mining. That part of oil sands bitumen deposits down below several hundred meters. I think certainly below 400 or 500 meters. much of that is accessible through open pit mines. And that's what, you've all seen the pictures of the enormous trucks and the enormous shovels loading bitumen onto the trucks. These are mining operations, in many ways no different from the metal mining operations that you have here in Quebec in abundance. These are mines, okay? The other part of the industry is the deeper part of the bitumen deposits. And that is accessed through wells that are drilled into those deposits. And they're produced through a system that is usually referred to as SAGD, okay, top of the screen, steam-assisted gravity drainage. And the way that is done is that steam is injected into the bitumen formation, thus diluting it and permitting it to be produced as oil and gas resources are normally produced through wells. The fuel for producing the steam is natural gas. There have been proposals for new hydro dams to produce electricity, to produce steam and the like, but natural gas is cheap right now and abundant. And so that's the system that is used. This screen also gets us back to the constitutional discussion of yesterday through Nathalie Chalefour's presentation, and Fenner Stewart's presentation. I'm approaching this from the point of view of regulating, the constitutional power to regulate the oil sands development, okay? And that's why you see the constitutional powers on the screen. So the development of natural resources within the province, transportation, upgrading, reclamation. This is property and civil rights stuff. And management and sale of public lands, 92.5 and 92A. Remember the Resources Amendment that was really so exciting back in 1982 when the Constitution was patriated? All of this shows you the constitutional powers in the federal government in relation to resources within the province, okay? Provincial powers. And then on the federal side, interjurisdictional transportation, the pipeline part of it, and trade and commerce, the international part of the pipeline system and the sale into markets. And you're all aware that there's only one market for Canadian oil and gas of any kind, and that's the U.S. And recently, the discount from the West Texas Intermediate price that you see if you look at the indices or if you look in the media at the daily price reports has been over $50 a barrel. So if West Texas Intermediate is showing up as it did recently at over $70 a barrel, the producers in Western Canada are getting less than $20 a barrel. And we're in this position because we have no pipelines to bring this oil and gas to ports and thus access markets outside the United States. So you can hear the grinding of the teeth of the oil executives from here. This has been a serious issue, okay? The federal powers, as you can see, the fisheries power is significant in the development of oil sands mines, taxation power, and I've referred to criminal law. I left off the POG power because I wanted you to notice it. And that's the discussion yesterday, okay? But the discussion yesterday was not about the regulation of oil and gas resources in provinces, particularly the oil sands. It was about regulation of greenhouse gas emissions. So the perspective and the focus is a little bit different. Okay. Alberta's Climate Change and Emissions Management Act, that was mentioned yesterday, dates from 2003, one of the very first of these systems. It was described as cap and trade. It was really a trade system with a sort of best efforts cap that was never formally stated within the legislation. So it was an aspirational cap, right? What we are going to achieve in 2020, 2030, 2050. That was the cap part of it. And then the specified gas emitters regulation that implemented the system goes back to 2007. Intensity-based targets, the targets being the limits for the particular major emitters, and it was limited to major emitters in the province. Intensity-based, okay, emissions as a function of production, as a function of output. And so in the glory years of oil sands development, that meant that while individual emitters were becoming more efficient in greenhouse gas emission from their operations, with all of the new mines and oil sands facilities coming on stream, emissions were going in one direction, okay? So the system provided that compliance could be achieved in three ways: by emitters investing in reduction technology. Secondly, they could purchase credits from firms that had overachieved in terms of emissions reduction and thus had credits to sell, or they could pay $15 per ton that went into a fund, like the Quebec Green Fund, okay? And as I've said, essentially there was no legal cap, there was an aspirational cap. Recently, this system has been overhauled, and it's been overhauled to work with the addition of a carbon tax in Alberta. So Alberta now has a dual system. This, what I've called a trade and sort of cap system first, and then secondly a carbon tax that was introduced in this year, 2018. Actually, 2017 is when it was put into place. And the final part of this is a cap on greenhouse gas emissions of 100 megatons annually. And then another part to this is the carbon capture and storage initiative that has been going on in Alberta for a number of years, right? The idea of sequestering CO2 emissions from energy operations in deep formations, and ideally making sure they stay there. One of the issues has been the action or lack of action of the Alberta Energy Regulator concerning requirements for mitigating greenhouse gas emissions by oil sands plants when they are approved initially. There's little doubt that this is within the jurisdiction of the Alberta Energy Regulator. But the AER and its predecessor, the Energy Resources Conservation Board, has not been, shall I put it, overly aggressive about this. And basically, in these approval applications, what the AER did is kick the ball over to the Alberta Environment Regulator, that is Alberta Environment and Parks. And so in one of the applications by Imperial Oil, its Curl Oil Sands Mine in 2007, this was a joint panel of the Alberta Energy and Utilities Board, as the regulator was then called, and Canadian Environmental Assessment Agency panel. Okay, so it was a joint panel. And in the panel report, the joint panel simply said, Imperial Oil has addressed greenhouse gas emissions by, quote, supporting Alberta developing appropriate APEA, the Alberta Environmental Protection and Enhancement Act, approval requirements to address various air emissions control and monitoring matters, including greenhouse gas emission targets. That's basically all it said about greenhouse gas emissions. That decision in that regard was challenged in a judicial review application by the Pembina Institute in Alberta, and the federal court agreed with the Pembina Institute that the panel report showed no basis for the insignificance conclusion concerning greenhouse gas emissions, and concluded that that decision was not justified, okay? There was no basis for it shown in the panel report. So this is the administrative lawyers among you. So this is reasonableness in the classic Dunsmuir mode, right? The decision is unreasonable in the sense that there's no justification shown for the decision. The federal court sent the matter back to the panel for review. The panel proceeded to review it and conclude, well, we have to give Alberta's per barrel intensity target approach considerable weight, period. That was it. That was it. And further, they said, as a result, there's very little evidence that the project will result in significant environmental effects. In other words, they gave the same decision as the initial decision. And on that basis, the federal government was in a position to fast-track the Fisheries Act authorization, which was the other main part of this regulatory process, and the Curl Oil Sands mine is in production today. So there were a number of Alberta Energy Regulator decisions in which greenhouse gas emissions were handled in essentially the same way, right? The regulator's decision said, well, this is a matter for Alberta Environment and Parks, and there's a system under the Alberta legislation that's for them. So no conditions were attached to these oil sands plant approvals. And you can see from this that there are two regulators here. There's an environment regulator, Alberta Environment and Parks, that's the ministry, and the Alberta Energy Regulator, as it's now called, that's the Alberta Energy Regulator. There's actually another part to this, of course, on the environmental impact assessment side, right? And the Curl application I've just described was one of those in which a panel joint panel that involved a Canadian Environmental Assessment Act participation was involved. So, enforcement and compliance. Basically, there haven't been enforcement issues that have been raised, that have been matters of dispute that have gone either to court and judicial review proceedings, or have been the subject of prosecutions in the judicial process. All you can find, essentially, is generic approaches to enforcement in the legislation, both on the Alberta Environment and Parks side and on the Alberta Energy Regulator side. Reporting requirements are a major part of this, and potentially can be the subject of enforcement actions, and ultimately can be the subject of prosecutions. The other part of this that is commonly seen is administrative monetary penalties, and these are built into the systems, both from the point of view of Alberta Environment and Parks and the Alberta Energy Regulator. So, integrated compliance framework, as the AER describes it, they look at a series of relevant factors in deciding what enforcement action to take, and these include: have there been complaints? Is there an emergency situation of one kind or another? What's the operational history of the facility that's the subject of complaint? Are there potential adverse effects that can be identified? Are there unique elements to the situation? All of these factors are taken into account. And then there are a series of tools that you can see on the screen. So, warnings, administrative orders that could potentially be shutdowns, though we haven't seen any shutdowns. Administrative monetary penalties, as I've mentioned. Jonathan, civil penalties, right? That's what we're looking at. And we've actually had a recent Supreme Court of Canada case that has confirmed the constitutional validity of administrative monetary penalties, because there had been charter challenges to administrative monetary penalties on the ground that legal rights are denied, and the theory was that these are equivalent to a charge. And in the circumstances of the AMP process, there's no opportunity to make answer, right? The administrative monetary penalties are simply assessed and delivered by the agency, and there's a series of categories that correspond to monetary amounts based on the criteria that I mentioned previously. And so it's like a ticket that's delivered to the offending company, right? There's no opportunity to challenge. And so the Supreme Court of Canada, in a non-environment, non-oil and gas context, because these administrative monetary penalties are used in other areas as well, has confirmed that no, charter rights are not violated. So, Alberta Energy Regulator, there's lots of information up on the website on the potential for prosecution, though there haven't been any prosecutions of this kind. There's a compliance dashboard that gives considerable detail of the enforcement actions, the inspections and so on that are carried out weekly and monthly. All of that information is available to the public, okay? And that's a desirable feature of the process that we can see. Industry voluntary initiatives. COSIA, Canada's Oil Sands Innovation Alliance, this goes back a number of years, and various voluntary actions as a result have been taken by oil sands operators in Alberta that have resulted in meaningful decrease of greenhouse gas emissions. But these are voluntary and consequently not formally enforceable. And the federal role, we heard a lot about the federal role yesterday. I'm certainly not going to rehash the discussion about the Greenhouse Gas Pollution Pricing Act. My take on the constitutional challenge is that, I think I asked a question about this yesterday, it is likely to be decided on the basis of the taxation power. I simply cannot imagine the Supreme Court of Canada worrying its way to a conclusion on that's based on the peace, order, and good government power, or on the criminal law power. So I'm disagreeing, I guess, with Professor Chalafour and with my colleague Fenner Stewart in Calgary, who was very high on the criminal law power. So for me, that's the bottom line. And there's one other element to this that I want to mention. The North American Commission for Environmental Cooperation. Has anybody heard of this? Is anybody familiar with, okay. Based in Montreal, this is the side agreement to NAFTA that somehow has flown below the radar, even President Trump's radar. It has not been mentioned in the renegotiation of NAFTA that's resulted in the new trade agreement. Still exists, and NAAC, the agreement, makes provision for enforcement submissions by citizens or NGOs who can file formal complaints alleging that there has been a failure to effectively enforce environmental legislation. Those are the words, failure to effectively enforce environmental legislation. And we have had enforcement submissions concerning the oil sands by Canadian NGOs, also by American NGOs. Okay, there have been several of these, and the most recent has, in the last few months, gone to the final part of this process, which involves essentially an investigation that produces something called a factual record that is then disclosed to the public. So there's nothing enforceable that comes out of this process. It's supposed to be a sort of spotlight process that shames the offending government into submission. And so this process is going on right now with tailings ponds in the Alberta oil sands. And the greenhouse gas emission significance of this, dry tailings produce a whole lot less greenhouse gas emissions than wet tailings. The issue in these submissions is the hydrocarbon content of the tailings ponds and the leaching from the tailings ponds that has gone into particularly the Athabasca River and has the potential to harm aquatic species in the Athabasca River and to pollute groundwater on the way to the Athabasca River. But there is a greenhouse gas significance in this as well. So, in conclusion, Alberta, you've seen Alberta implementation. What has happened in Alberta? The systems that Alberta has. Alberta is going to be one of the provinces, despite Premier Notley's comments that resulted from her perception of federal, well, call it federal cowardice concerning the Trans Mountain Pipeline. But Alberta is one of the provinces that is in as far as the federal scheme is concerned, okay? So the federal scheme is not going to be directly applied in Alberta. But there are certainly issues about how the federal legislation is going to be applied, and we've seen that actually in the last couple of days, announcements about how rebates are going to come back to citizens in the provinces in which the federal legislation is applied as a backstop. So the CBC political panel that I tuned into last night was suggesting, hey, there's going to be rebellion in the country. Why? Because one of the panelists was suggesting that one result could be that Saskatchewan citizens get bigger rebates than Ontario citizens. Remember? And remember, it was Saskatchewan that was out of the federal scheme right from the beginning. And the basis for that seems to be that the rebates, part of the foundation for the rebates is the intensity of emissions, and Saskatchewan's economy is more energy-based than Ontario, and as a result, the emissions greater in that sense. So the per capita payments to Saskatchewan residents will, as a result, be greater. So we'll see what happens, and of course, it's just a little less than 1 year till the election. So is this going to be an election issue? Is this going to be an election issue? Is it all going to fall below the radar? How many citizens in Quebec have been extremely worried about carbon taxes? Right? You've had a carbon tax in this province for what, about 8 years now? About 8 years now. In British Columbia, about the same. So there are two provinces in which that's not likely to be an issue. Alberta doesn't figure in federal elections at all, basically, and so it all comes down to Ontario. So that's the end of my presentation, and that's the uncertainty on the federal side. So thank you very much.